Thus, the plaintiff has not shown an entitlement to this extraordinary relief, and we reverse. Wild. She now seeks to cause the harm that she said that she must avoid. Like, we have to get him out on time, because if we don't get him out on time, then people aren't going to have that enough time to go and vote. The court just said it's discretionary, so do whatever you want. So why are you keeping a candidate who's not running on the ballots? Is it to rig the election? Yes, it is. Joceyln Benson, one of the biggest cheating secretaries of states in our country, in my humble opinion, is now out with a new book. It's going to be on sale May 6th. I know you're excited to purchase it, but it says that Joceyln Benson is the purposeful warrior. Shing! Standing up for what's right when the stakes are high. And so she dropped this one September 9th at 7:08 in the morning. And you can see she's very proud of herself and that nice photo, like she's a hero. Now, ordinarily, I'd say these photos are pretty goofy, and you see it when people put them on their covers. And there's something wrong with that, I suppose. And it's okay if other people put the photo of you on that. If like somebody else is like, wow, you're a really heroic person, like a saintly figure. But she's just Joceyln Benson. There's not like a real urge for her to come out and like do this, right? Unless she's fighting for a purpose of stopping Trump. Yes, that's how you get a market. That's her cause. That's her whole basis for existence. The purposeful warrior. Well, what's your great purpose, Joceyln? Saving democracy against Trump. And she's working hard to do that. One thing that she has done is become the Secretary of State and done everything she can to rig the state against Trump and against democratic principles. Joceyln Benson has been successful in the Supreme Court out of Michigan in securing RFK Jr.'s place on the ballot. This was a 5-2 decision reversed against Kennedy by the Democrat Michigan Supreme Court. Looks like it was a 5-2 decision. We've got 2 justices dissenting here, but as this stands, RFK Jr. is going to be on the ballot. So here's what the Democratic Supreme Court from Michigan has said. On order of the court, the motion for immediate consideration is granted. Now, this comes up from the Court of Appeals. The judgment that we read here on the show on September 6th says, in lieu of granting leave to appeal, right, we could give you permission to file an appeal, and then this could take a while and we could address all this in due course. They say, we're just going to do it now. We're just going to handle this. They're like, we're going to handle it right now. RFK needs to be on the ballot. Let's print these things so we can rig this state. We reverse the court and the judgment of the Court of Appeals, and we vacate the opinion and order of the Court of Claims and do deny the immediate mandamus relief, which was to take RFK's name off the ballot. So to mandate his name goes bye-bye. And the motion for the stay is denied as moot. So here, let's go through this, saying that RFK filed the motion seeking a writ of mandamus, saying that he wanted the government to take his name off the ballot. She said, nope, it's staying on. He said, I'm not running. She said, too late. The motion was docketed on September 3rd. Now, to obtain the extraordinary remedy of a writ of mandamus, RFK bears the burden of showing that RFK had a clear right to the duty to have his name removed, clear right, that the defendant, Joceyln, the secretary, has a clear legal duty to actually do that. So he's got a right to get his name off the ballot. She has a duty to get it off the ballot. The act is ministerial, so it's not like a discretionary decision. It's not like you're forcing her to spend her budget to go do this thing versus this thing. No, that's her discretion. You can't force her to do that. This is just a ministerial task. It's like clerical work. And 4, no other adequate remedy exists. Now, a ministerial act is one where the law defines the duty with precision and certainty, and there's no discretion or judgment, right? You're not making a budget decision or something. The law says do it. Got to do it. So just do the thing. Now, assuming without deciding, they say, that the Court of Appeals was correct in its interpretation of the law, RFK has neither pointed to any source of law that prescribes or defines a duty to withdraw a candidate's name, nor demonstrated his clear legal right to have that duty, let alone identified anything with any precision or certainty as to leave nothing with the exercise of discretion or judgment. So they're just saying she's going to have discretion. These people are sick. Thus, the plaintiff has not shown an entitlement to this extraordinary relief, and we reverse. Wild. Now, this is another judge, Welch. He says, I'm joining in full. Why? Because the Natural Law Party, they opposed RFK's request, and he ran as one of their candidates, saying that the Court of Appeals appoints the nominations, handles the nomination process, and so on. And so he's concerned about some other things. Now, here's the dissent. The intelligent judges who know what they're trying to do here are now going to explain why this opinion is problematic. They say the Secretary of State here, Joceyln, she seeks an order to put RFK Jr.'s name on the general election ballot as a candidate for president, claiming that his name must be on the ballot under Michigan law. But no statute prohibits the withdrawal of a candidacy. So nothing stops him from doing that. And there is no practical reason for denying a request to withdraw before the ballots have been printed for the general election. The ballots have not even been printed yet. There is, however, a significant cost to the integrity of the election, right? These election integrity people, they're going to have a bunch of people voting for RFK that are not going to count. He's not running in the state. The voters will be improperly denied a choice between persons who are actually candidates who are willing to serve if elected. There is a great distrust in the American voting system, and the ballots printed as a result of this lying court here that's putting fake candidates, not real, withdrawn candidates as placeholders on the ballots will pervert the true popular will and the outcome of the election. Dissenting judges are confirming this, right? They're doing it to affect the outcome. Now, Kennedy filed an action in the Court of Claims to compel Joceyln to remove his name from the ballot. Court of Claims denied it. On appeal, a unanimous panel reversed and ordered his name removed. But then the secretary, right, Joceyln, she filed an appeal on September 6th at 6:05, just to show you how rigged all this is. She files it at 6:05 and noted in its motion for immediate consideration that earlier, they said at 3:42, Joceyln sent the call of the election and the certification of the candidates to 83 county clerks without Kennedy's name listed as the Natural Law Party's candidate for president. Okay, so that's the deadline. Under the deadline, September 6th is the deadline for the secretary to deliver the list of candidates and ballot questions that will appear on the ballot. Okay, so this is also wild. So in other words, Joceyln did her job at this moment. So the appeal came down on September 6th. Close of business is at 6:05. They confirm in their filing that at 3:42, she sent the list out. The list is due on September 6th. She sent the list out at 3:42. All 83 clerks got the names from Joceyln without Kennedy's name on it. All right. She complied. So now the court is going to reverse that. And I guess she's going to re-email everybody because this opinion just came back out on the 9th. So the Supreme Court is now going to be asking them to violate the September 6th deadline because the Court of Appeals ruled on that. Now, as matters currently stand, they say with Kennedy absent from the ballot, there has not been any violation of Michigan election law as it stands. The Secretary of State plainly had the power to remove Kennedy's name from the ballot, obviously, and the majority does not even question that power to remove Kennedy's name from the ballot. And further, Jocelyn's claim that Kennedy is barred from withdrawing his name under 686A is meritless. She can't do that. It doesn't even apply to the presidential election if you read the statute. And moreover, as Kennedy, RFK Jr., answered this morning, he provides the following acute observation. He said, the secretary, in fact, until this appeal, Joceyln screamed at every turn that there would be harm to the public interest if the identity of what candidates to print on the ballots were not finalized and certified this past Friday. We're all going to die if we don't get these names figured out. That occurred. We got the names. RFK Jr. doesn't want to be on the ballot. He asked for a withdrawal. You got it done. You sent notices to everybody. She now seeks to cause the harm that she said that she must avoid. Like, we have to get him out on time, because if we don't get him out on time, then people aren't going to have that enough time to go and vote. If she obtains a stay, she's going to upend the certainty as to the candidates to which she's certified to print on the ballots that they're going to start printing today. So she's going to make it less accurate and harm their efforts just to keep Kennedy on the ballot. Now, the language of 686 is unambiguous and it's clear. Candidates are not prohibited from withdrawing their names. But what this court is saying is that they're not given an affirmative duty. They're saying, well, there's nothing stopping you from leaving, but do you have the right to get off? The way the law is written, it says it's just kind of, yeah, take your name off. You don't have the right to do it. Moreover, even as admitted in the secretary's application, Joceyln, she has delivered to the county clerks the list of candidates to be on the general election. In short, the legislature created a process that would certify ballots for distribution to the local clerks. All this would be done by September 6th. That's the deadline. And the secretary has complied with this requirement. Accordingly, the current application, which asks the court to act outside of this, seems moot. And so you should not be exercising judicial power to sanction conduct outside of what the legislature provides. But nonetheless, despite the fact that Joceyln has lawfully delivered the list of candidates to the clerks and that the deadline has passed, this court is now intervening for her legally unsupported position. The deadline's passed, he's not running, and it does so on a completely novel claim, a claim not even advanced by Joceyln herself. You say, Supreme Court of Michigan, that there exists no legal requirement for her to accept a withdrawal request at all. It's totally discretionary. She can just keep whoever she wants on the ballot. No provision in law supports that. Yet the court inverts the analysis, concluding there is no provision that still expressly permits Kennedy to get off the ballot. But still, after this court's intervention, there is no identifiable source of law that permits her to deny the request. The majority's counterintuitive and circular reasoning gives Joceyln extraordinary undefined discretion that's not found in the law anywhere. She can just reject any withdrawal as she sees fit. And so the court then implicitly holds that she made a discretionary decision, and she never even asserted that. So wait a minute, Joceyln. So it's your discretionary decision? So you can't come back out and say that you're bound by the law to make these arguments. The court just said it's discretionary. So do whatever you want. So why are you keeping a candidate who's not running on the ballots? Is it to rig the election? Yes, it is. In fact, the legal justification that she actually proffered and relied upon for her decision was totally meritless. Now, countless Michigan voters are going to be deluded. They're going to be deceived into casting their ballots for a candidate who has no intention to hold the office. And anytime they tell you about like voter disenfranchisement, well, you can't ask for voter ID. That's racist and bigoted. And, you know, it might stop illegals from voting in our elections, as the DOJ just indicted one from the District of Alabama. But there is no legal authority for the decision to deny the withdrawal, but they're saying, well, he doesn't have any authority to demand a withdrawal. Mandamus is the appropriate remedy here. And so this appeal should be denied. And so they dissent. That's obviously the right decision. They give us a lot more analysis on this. Here was Karine Jean-Pierre. I think this is her Big Bird outfit or whatever. She posted this one at the White House press podium today, talking about the free and fair election. Laughable.
Because our democracy was attacked. And they went there because they were told that they should overturn an election, a free and fair election, where dozens of Republican judges said that it was indeed a free and fair election. And so that type of rhetoric,
they didn't say that,
is dangerous and unacceptable. And that is not what this president believes. Because our democracy was attacked.
Yeah, everything's ma democracy. Again, ma Democrat power. Our democratic institutions are what they're really interested in preserving.